What's up, everybody? It's Stephen A. Williams, president and founder of creditrepairshop.com. And in today's video, we're going to talk about a debt collection firm that has been sued by the CFPB for illegal or debt collection violations, according to the Fair Debt Collection Practices Act. But it's not going to be in a way that you might be thinking. So I'm going to kind of break that down so you can understand. And this will kind of validate one of the things that I've always stated in my 3 free letters that I always give at the end of my video. And I'm going to kind of go into that right here. So it may not be exactly, the violation may not be exactly for the reason that you might be thinking of. So first, let's just show the proof. It says CFPB takes action to halt debt collection mill. And you know that you want to know why they call it a mill? Anything it's like a factory where they're just pumping out lawsuits or people pumping out products, over and over and over. They have one system in place and they just pump them out. So that's why they call it a debt collection mill, just so you can understand. From bombarding consumers with junk lawsuits. Now, when they say junk lawsuits, this is kind of misleading. The junk lawsuits that they're stating, it wouldn't be like they're buying debt and then they're reselling. They're buying debt that's being sold on the market. They were actually suing consumers on behalf of the original creditor. So this debt was not past the legal statute of limitations. That's why I believe that this article is kind of misleading, because it makes people think that, number one, they were buying junk debt. And then number two, what do they mean by collection mill? So Forrester and Garbus illegally sued borrowers on behalf of Citibank and Discover, among others. So that's very important. That's very key. On behalf of, it's not where they're saying that they bought the debt and then they were going out there trying to collect on it. This is on behalf of these banks. In previous videos, I stated that the original creditors have seen some of the successes that debt collectors have been having from when they would sell the debt, and then the debt collectors would go out there and have these lawsuits, and they were winning them left and right because people didn't know how to respond. People didn't respond, so they were getting default judgments all over the place, and then they were getting the money 100% of what the original creditor would have wanted to get, plus court costs by garnishing people. So what the original creditors have started doing is mainly Capital One, Discover, and American Express. But now you can see Citibank and some of the other ones are testing the waters to see how this will work. And they did not get in any trouble for what this debt collection law firm did, the original creditors. This was all based on what the debt collection attorneys did. Now, let me also, before I move forward, tell you why the attorneys from the original creditors don't go and try to sue. Like, you might be wondering, like, why wouldn't Citibank or American Express do their own debt collection and go and sue people and take them to court? The reason why is because it's against the law. Here in my state of Wisconsin, I'm pretty sure in your states, it's very rare that an original creditor like these that's also doing the financing, doing the lending, can also act as a debt collector. They would actually have to go and get a debt collector's license, and they're not going to want to make a whole department, make all of these policies and procedures, and do all of that stuff to have another company when they're in the credit card company. That's where they're in. They're in the credit card business, not the debt collection business. So that's the reason why they'll go out and they'll hire out firms, debt collection attorneys, to go and collect their debt forms. So now let's move forward here so we can get into the meat of what this whole lawsuit was about. So Consumer Financial Protection Bureau has reached a settlement in a lawsuit against the firm Forrester and Garbus LLP for illegal debt collection practices. If approved by the court, the proposed settlement would be prohibiting Forrester and Garbers from filing any new lawsuits against a consumer unless it has specific documents supporting the debt and certifies that an attorney reviewed those documents. The order would also require that the company to dismiss any pending lawsuits where it cannot satisfy these requirements. So if you're currently being sued by this company, all you need to do is you need to make a request to make sure that an attorney reviewed, don't want to get that line there. An attorney reviewed those documents. That's in the three letters that I've always given: statute of limitations, cease and desist collection activities letter, and the debt validation. In the cease and desist collection activities letter, it specifically states that an attorney review the documents. Let me tell you, you might be saying, well, why would they take the documents and not have an attorney review them? Because once that attorney reviews them, it takes it up a notch on this attorney is attesting that those documents are true. So when they go into court, when they go in there as an attorney, they're swearing that everything that they present to the court is true from their understanding. Now, I know that there's a lot of gray areas in there, but when it came to debt collection, though, that they had never reviewed those documents. And so what they'll usually do is they'll send the lowest level attorney into the court to sit there. People come popping up, hey, call their name. What are you going to do about this debt? I'm not going to do nothing about it. I don't know what I'm going to do. And then some of the people challenge, maybe they, got some help from our company and they ended up challenging those documents. And in the process of challenging those documents, they said, hey, well, before we even go there in court, let's just go with the cease and desist collection activities letter that I put together. It specifically asks if an attorney reviewed all of the documents and if everything that you're alleging in your Dunning letter is true. Like did an attorney review it and say, hey, I looked at the accounting, I looked at the charges, I looked at the person's name, I looked at the address, I looked at all of that stuff, and I know that we can proceed, that we have legal grounds to proceed with this if we want to take it to a lawsuit, but also we have legal grounds to go after them as a regular debt collector, to just make those calls. Did an attorney review those documents? They have to review them. And so their statement here is that the order would also require the company to dismiss any pending lawsuits where it cannot satisfy these. I don't want to my line here, where it can't satisfy these requirements. And it would also require them to pay a $100,000 penalty. And then, so it said here also that bombarded its customers with sketchy lawsuits on behalf of big lenders like Discover and Citibank. So they were just pumping them out, and really, this here really did happen because most people don't show up for the lawsuits. Most people don't. And then you'll have someone that gives those documents and asks those questions and say, prove your case. Because remember, it does not matter. Like, a lot of people make this misconception. If you have a debt with an original creditor or debt collector, you still have the right to make them prove their case. The only reason why they have default judgments is because people, number one, don't challenge the documents, and number two, people don't show up to court. Like, that's the reasons why. You could win your case or put yourself into an excellent position to have a settlement offer presented to you where you would be like, just to make this stuff go away, I'll do the settlement. I did, it was my card. I'm willing to do it. Or if you want to take it a step further, because these companies are in business, and if they don't maintain the documents, you can do this. If you need to feel good about beating an original creditor when it comes to lending, if you need to feel good about it, because there's a whole bunch of people out there that'll try to make you feel bad about it. And I'm not the one that's telling people to run away from debt, but we're talking about situations. We're talking about you're struggling financially. You just cannot pay the debt. You need to be able to move forward. You don't want to file bankruptcy, or you can't file bankruptcy. Even though if a company, we flip that over, if a company, the same company that would be coming after you for the money, was in financial trouble, they would either be able to get a bailout from the federal government, or they would be able to file Chapter 11 bankruptcy, or just flat out full bankruptcy. They would be able to do that. So why would you not be able to look at all of the options that are on the table for you to be able to take care of what's on the table with a specific debt? And one of the options is, if they're suing you, or even before they're suing you, is to make them put all of their cards on the table and see what they have, because they may not even be able to prove that they have the legal right to collect the debt. So in this situation here, what they basically got caught doing was they wanted to pump out, they said it was about more than 136,000 accounts were placed with them from 2014 to 2016. So this was just within a 2-year period, 136,000 accounts. So you would be able to, so it would be good to make them put everything on the table so you can see what would be your options. You have the right to do that. And just like I said, they would be able to file Chapter 11, Chapter 7, whatever they would be able to, for business, they would be able to file, or to get some type of a bailout from the federal government. Your job is to try to get the best resolution for yourself and your family. And if it comes to where they don't have the information, regardless if it's from the original creditor or a debt collector, if they don't have the documentation to prove everything about you being able to pay the debt, you would be able to win. Now, with this situation here, this specific situation, what happened is that they were just, piling them up. They were just, in a way, robo-signing everything, get the documents, send them to court. It was like a factory, a lawsuit factory. That's what they were basically doing with this one. Not to say that they couldn't win if they did it the right way, because they were with the original creditors. They would be able to get all of the documentation to prove their case. But because of what happens on the other side with debt collection companies who buy debt, and they were having so much success with people not showing up to court, not challenging the documents that they had, it was just easy for them to be able to just, to get the money from people and have a lot of default judgments. So if you find yourself in a situation where a debt collector is coming after you at the beginning, before they try to take it to a lawsuit, you got that 30-day letter. I have a 3-pack of letters that's below this video. It has a cease and desist collection activities letter. That's if your debt is past the legal statute of limitations to collect. Number 2, cease and desist is for debt that is not past the legal statute of limitations to collect. That has this piece right here in there. I have a line already placed in there for that. I give you a debt validation letter where you can go back and forth, because they're going to respond, and then you're going to need to have something to go back and forth. Read it. Don't just take the document. Read it. Put your information on there the right way. Send it out. It could stop a debt collection company, especially if they purchase your debt, from coming after you. It could potentially, with the back and forth, get the original creditor to file a 1099-C, cancellation of debt. Now, if your debt is past the legal statute of limitations to collect, you normally wouldn't run into this with an original creditor sometimes, but you will most likely run into it with a debt collector who purchased your debt. You need to find out what the statute of limitations for collecting debt is in your state. It's different for every state. You can go to my website, thecreditrepairshop.com, and check that out. And you just go to my blog at the bottom, type in statute, and then you'll see in column number 1 is for regular loans like an auto loan, type of loan that you just pay down, installment type loan. Column 4 is credit card, open type accounts, line of credit. And the statute of limitations sometimes is a lot lower in the open accounts, the column 4. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you can see my 8-point validation process and my 2-phase settlement process. That's the way that we repair credit. If you need your credit reports and scores, go to the website your3scores.com. Grab your TransUnion, Equifax, and Experian credit reports and all 3 scores. And again, remember to grab my 3-pack of letters. If you have debt collectors coming after you, you can utilize those letters to stop debt collectors. And I also ask for a donation. Helps me for my time here on the channel. I appreciate everyone who makes a donation for grabbing those letters. Thank you for your time. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.